All right, good morning, everyone. I'm Judge Jackie Powell, and we are in first appearance court. Today, we're going to address all those of you who've been recently arrested, and we'll talk about probable cause, and then we'll also talk about release conditions. Today is not your trial date, and so I encourage you not to say anything on the record because everything in this courtroom is being recorded. If you are represented by an attorney from the Public Defender's Office, we have Attorney Brian Reedy, who is in the courtroom. And over at the main jail, you have Attorney Hector Romero. If you're represented by the Public Defender's Office, you may speak with one of them before speaking on the record. If you are represented by a private attorney, those attorneys usually come physically into the courtroom, and they will be able to speak on your behalf. If otherwise you have an attorney who's not here, we can address that at the time that you come up. You need to know that in the courtroom, there's also an attorney from the State Attorney's Office, Mr. Eric Linder. We have confinement status, and we have pretrial supervision representatives here as well. The clerk of court is also here to maintain the records in the courtroom. I have read all the probable cause affidavits, but from time to time, attorneys will make arguments, and so we will address everyone individually. And we will start this morning with Stephanie Starling.
Starling is in North Broward, Your Honor. She'd like to resolve this matter this morning.
All right. All right, Ms. Starling has a state charge and also a municipal ordinance violation. These are both misdemeanor capious matters. State, do you have an offer on the state charge?
Adjudication time served.
All right, Ms. Starling, if you wish to resolve your cases today, the sentence for both counts will be adjudication and time served. Do you wish to resolve your case with that offer?
Yes.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Ms. Starling, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Have you ever been treated for mental or emotional illness?
Yeah.
Is there anything about those treatments that would affect your making a decision this morning?
No.
And do you understand that you have the right to go to trial, but by taking a plea today, you're giving up that right?
Right. Yeah, I understand.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, I understand.
What plea do you wish to enter, Ms. Starling?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served on both counts. And I'll give you 6 months to pay your court costs. Good luck.
Thank you.
Tammy Trotter.
Judge, she's here present at Maine. She's approaching. Come on up, ma'am.
Good morning, Ms. Trotter. You're before the court for petty theft, and the court does find probable cause.
Judge, in speaking with Ms. Charter, she wishes to see if the court would be willing to resolve this matter today.
Okay.
Offers adjudication time served, no return.
She wishes to accept the state's offer, Judge.
What is this? Where's this location? Publix?
Walmart.
Walmart?
In Hallandale Beach.
Okay. All right. So, Ms. Trotter, adjudication and time served, no return to Walmart. Do you understand that?
Yes, ma'am.
All right. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right. You can put your hand down. Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
That's right.
No.
And do you understand that if you're not a U.S. citizen, By taking a plea, it could subject you to deportation or immigration changes.
Yes, ma'am.
What plea do you wish to enter?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given. Your sentence is adjudication and time served, and no return to that Walmart in Hallandale Beach.
Good luck, Your Honor.
4155.
Jacqueline Dorfman,
She's a medical reset, Your Honor.
okay.
Your Honor, do you know if PC's been found in this matter?
4155.
No.
Okay, thanks.
Looks like it's from over the weekend, and there's no indication that PC was found. So. All right, as to Ms. Dorfman, the court finds probable cause. We can reset for resolution or bond discussion later. Yes. Sabrina Rosenbaum,
She is in Paul Ryan, Your Honor.
okay. All right, Ms. Rosenbaum, you are before the court for driving while license suspended on count 1. Counts 2, 3, and 4 are felony violation of pretrial. Those have bonds that are attached to it, and it's not for magistrate. And then count 5 is an out-of-county hold, which is a no bond hold, and also not for magistrate. The court does find probable cause. Looks like for your felony matters, you'll be before your division judge tomorrow at 8:30. And the bond on count 1 is $100. Good luck. Richard Berthoff.
He's here present, Judge at Maine.
All right, Mr. Berthoff, you're before the court because you have an out-of-state felony hold, and that hold is a no bond hold, so you should be going before the extradition court shortly. And that's New York. It's out of the state of New York. Okay? Thank you. Frederick Colvin.
He's approaching, Judge here at Maine. He's here.
All right, Mr. Colvin, you're also before the court for out-of-state felony hold, which is a no bond hold out of the state of Illinois. And so you two will be going to extradition court shortly, okay? Mert Balta.
Judge, Mr. Bolta is here present at Maine. He has private counsel, Mr. Kevin McGill. I believe Mr. Reedy attempted to contact him.
I
Okay.
did speak with Mr. McGill's office. They are texting him as we speak to come by.
Oh, okay. All right, Mr. Balta, I'll recall your case.
Yes, Judge.
Tony Sheffield.
Mr. Sheffield, come on up, please. He's approaching.
Mr. Sheffield, you are before the court for aggravated battery with a deadly weapon. It's a domestic violence. And then count 2 is a parole violation. That's a no bond hold, so you will be going before the parole board shortly. The court does find probable cause. As to count 1, does anyone wish to be heard as to the bond?
Your Honor, I'd be requesting a $5,000 bond in order no victim contact. Noting the case, he's on parole, at least one of them. It was 2 separate cases of strong arm robbery. He was sentenced to 18 years state prison as a habitual offender and a PRR offender. He's been sentenced to prison as a habitual offender for burglary of a conveyance, attempted strong arm robbery, burglary of a dwelling, grand theft auto, and he's got a prior carry and concealed weapon.
Judge, Mr. Sheffield is financially indigent. He gets disability. He gets approximately $514 per month. He lives locally here with his father. His father is on Social Security. So, Judge, I'm going to ask you to take that into consideration in determining a reasonable monetary bond for count 1.
The court does find probable cause. I'll impose a bond of $2,500 on count one. Travis Green,
I believe I got a message that they wanted that to be reset to the afternoon.
Yeah, confinement?
he's gonna be reset to the PM. Okay. Brian McQueen,
Mr. McQueen is approaching judge. He informed us he has private counsel, and I believe Mr. Reedy was attempting to get in touch with his private counsel.
Yeah, but I don't know who his private counsel is.
who's your attorney?
Karim Neff.
What was that?
Karim Neff.
Karim, how do you spell the
Neff.
last name?
KARIMNEFF.
All right, well, do you know if your family has spoken to Mr. Neff in regards to this arrest?
No, ma'am.
All right, so how is he your attorney on this
It's
case?
fine. I have used him in previous cases. I don't actually have him for this case, but if I can take a PD this morning, that's fine.
All right, so just so everybody understands, just because an attorney represented you before, unless your family contacted them for this arrest, they are not your attorney. Okay? All right.
Yes, ma'am.
So if you need a few moments to speak with the attorney from the public defender's office, I will recall your case.
No problem.
All right. Marcus Zapor.
Mr. Support is here present, Judge Amin. Come on up, sir.
All right, Mr. Zapor, you are before the court. Count one is battery, second or subsequent offense, and count two is false imprisonment. The court does find probable cause. And I'll hear from the parties as to bond.
Your Honor, the state is requesting a $5,000 bond on count two. A $5,000 bond on count one also based on the specific allegations of battery in this matter, considering it also is domestic in nature. I would also note it appears that Mr. Support is on probation before Judge Weeks for criminal mischief. 2009, solicitation on a felony, resisting without violence, 09, obstruction, unlawful use of false name identity, 06. The battery that's referenced in the report, Your Honor, it's a felony battery, great bodily harm. He violated probation, was sentenced to 37 and a half months in Florida State Prison. Nothing further.
Okay?
Judge, I'm going to ask you to leave the bond on count one as is, $1,000, and I'm asking on count two, the court to set the bond at $2,500. Now, he's 32 years old, been here his whole entire life. He is working. He works for Whole Foods, and he's going to be living separate and apart from the alleged victim. He's going to be living with his brother in Pompano Beach, and his brother's the person he's going to be relying on to help post his monetary bond. From what he informed me, his brother works as a cook, so he believed if the court were to set a total of $3,500, that his brother and his family may be able to afford that. That's why we were asking for that, and I'm going to ask the court to sign a photo order.
All right, the court will sign a photo order. I do find probable cause, and I am going to impose a bond on count one, $10,000, Count two, $5,000, no victim contact.
As far as I'm concerned.
And no return to this location. Joseph Gramanzini, is this on Gramanzini? That's okay, we all need to grow some arms. All right, on Mr. Gramanzini,
Yes, Your Honor.
all right, this is it's an upcharge from a misdemeanor.
Yes, Your Honor, but I don't think it needed to be put on the docket. As you can see, he went before Judge Lerner Wren on this change of charge KPS previously, earlier
Oh.
this month. What happened was, if you look on your KPS,
Yes.
it had to be corrected. I provided the previous KPS. On the original change of charge KPS, they put the wrong case number, and that was corrected. I don't know
Okay.
why he had to have his first appearance all over again, but Judge Lerner Wren said $1,000 bond originally. I'd asked that be placed back on him. The only other thing I'd asked the court to do, I checked in Odyssey, and I don't see that a new no contact order has ever been issued on the felony case. So I'd ask that the court would order no victim contact.
All right, Mr. Gramanzini, you're here today just on a technical matter. So it's the same charge as you were previously before the court on earlier this month. So your bond is still $1,000, and then there's a no contact order, no victim contact, okay?
Yes,
You also will be in court tomorrow, in your division, before your division judge, okay?
okay, but can I say something? I was here Sunday, and the judge says $1,000 bond was $100, and she said, "Could I afford it?" And I said, "No," and she put me on a monitor, and I have somebody to bond me out.
It's not a separate case.
I don't have that information on this case.
The guy just said that, didn't he?
That was
No.
a different case, Your Honor.
That was not this case, that was another case, and I can't address a case that's not in front of me right now. Okay? All right, Russell Shurik.
Judge, I'm sorry, who did you call?
Schurich.
Mr. Russell Sharish, come on up. And Judge, whenever the court's ready, I'm ready to proceed on Mr. Brian McQueen.
Okay,
Yes, miss. How do you pronounce your last name, sir? Surridge. Surridge, okay.
Mr. Surridge, you're before the court for trespassing on school grounds. The court does find probable cause.
Judge, in speaking to Mr. Surridge earlier today, he wishes to ask the court would consider resolving this matter.
All right,
Your Honor, just to put on the record, upon reading this PC, I had some concerns about potential mental health issues.
Judge, if the court's not inclined to resolve this case, my understanding is that Mr. Surridge is homeless. He's financially indigent. He can't afford to post a monetary bond of 25, nor can anyone else. So we're asking to consider releasing Mr. Surridge ROR.
yeah, there are questions about the mental health, so, I'd be willing to, transfer this to Judge Lerner Wren,
I'll notify her, JA, Your Honor.
so that he can be in court as soon as possible, and I'll leave the bond in place, okay?
Yes, Judge.
All right. Timothy Kylo.
Mr. Kylo is approaching, Judge, this morning.
All right, Mr. Kylo,
Yes, ma'am.
is this a municipal ordinance?
Yes, Your Honor.
How are you? All right, Mr. Kylo, you are before the court on a misdemeanor KPS matter on a municipal ordinance violation. Shipping container. Mr. Kylo, what do you wish to do today?
I'm sorry.
What do you wish to do with your case today?
I'd like to resolve it.
All right.
Judge, they have all the time, sir.
Mr. Kylo, if you wish to resolve your case, it'll be adjudication and time served.
Okay.
All right, please raise your right hand as best you can.
Yes, ma'am.
Do you swear or affirm to tell the truth?
Yes,
All
ma'am.
right, sir, you can put your hand down. You can put your hand down.
Okay.
All right, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, Your Honor.
And you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, sir?
I'm sorry, what, ma'am?
What plea do you wish to enter? Guilty or
Oh,
no
no
contest?
contest.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck.
Okay. Thank you, dear. Your Honor.
Jeffrey, all right, Mr. Romero, Brian McQueen.
Mr. McQueen, come on up, please. We're ready to proceed on him, Judge.
All right. So, Mr. McQueen, you are before the court for domestic battery by strangulation, and count 2 is battery causing bodily harm. Court does find probable cause. Mr. McQueen, yes. Oh, well, he had said that he would proceed with the public defender because he hadn't, yeah. All right. So anyone wish to be heard as to the bond?
One moment, unless the public defender would like to go first, that's fine.
Okay.
No, I'll wait for Mr. Leonard because I can speak to Mr. McQueen a little bit more.
Jeez. All right, one moment.
Judge, thank you. I just finished finding out one additional piece of information. And speaking with Mr. McQueen, unfortunately, from what he advised me, he's going through a very difficult financial time right now, and he basically can't afford anything. He is working, however. He works for a company called Land and Sea, where they load trucks, and he's been employed there for 1 year, making approximately $12.50 an hour. He's been here his whole entire life. He's 33 years old. He will be living separate and apart from the alleged victim. He's going to be reside with his family members, who reside specifically his sister in Lauderhill. Now, my understanding is also his family are also going through financial tough times, so they're not going to be able to afford to help post his monetary bond. So, the judge, Mr. McQueen, financially really can't come up with anything, but so we wanted to have the court take that into consideration in determining reasonable release conditions for Mr. McQueen.
Your Honor, the state would be requesting a $10,000 bond on count 1, $2,500 bond on count 2. No victim contact. This is based on the allegations. States based on the strangulation, the victim felt like she was losing consciousness. She advised she's in fear for her life with respect to Mr. McQueen. With regards to the battery, it's noted that she suffered scratch marks. There was blood on the left side of her neck and a busted lip. As far as his criminal history in Broward, an arrest for possession of firearm or ammunition by a convicted felon in 2015, that was dropped. Resisting without violence, 2013. Out of Collier County, he has priors for grand theft, giving a false name. He has a prior battery in 2006 out of Fort Pierce. Another false name or ID. St. Lucie in 05. Nothing further, Judge.
Okay. All right, as to count one, the bond is going to be $10,000. On count two, it's $2,500 and no victim contact. All right, Jeffrey Piscioni.
He's approaching, George. Come on up, Mr. Piscioni.
Mr. Shades, you found all your cases already?
I do, Judge. It's just the two Rodriguez's at the bottom of page 9.
Judge, I've been advised Mr. Piscioni is going to be a medical reset.
Oh, okay. All right.
Harold Julian?
All right, let me call a few of Mr. Shade's cases. Miguel Rodriguez on page 9. All right, Mr. Rodriguez is before the court on a misdemeanor KPS for a possession of controlled substance charge. The court does find probable cause.
There would be a time served offer, but I would like it if possible that we could be able to withhold so we can keep any driver's license he may have. I'm not sure if he has one or not.
All right, do you know if he has, are you not sure if he has a driver's license?
Mr. Rodriguez, do you have a driver's license? Can you hit the button? Hit the button there.
Can someone turn on the mic?
I have one, but child support has it, so it's suspended.
All right, well, we're going to suspend it for another year, so.
I didn't hear you.
It'd be suspended for another year if you were adjudicated. Are you able to make a bond? Are you able to post a bond?
You gotta
hit the
press the
button
button
again.
and leave it. Turn it on and leave it on. All right.
I have a
No,
job
hold your
at
finger on
Take your
landscaping, but
take your finger off of it now, and then
Okay.
speak. And then speak.
okay, I have a job, but right now I came to take care of this. This is a ticket I caught last year. I didn't even know it was still effective. But I don't have a driver's license right now. I'm trying to get my driver's license back so I can make more money at my job.
Judge, is it possible we could have more award? I'm not sure what his criminal history is, and that way he can come and take care of it, make sure that he...
All right, this is an old KPS from last year, so I will ROR him on this charge. Sir,
Thank you, Your Honor.
Sir, you need to speak with your attorney to try and resolve this issue as soon as possible. Okay?
Make sure when you get your court notice that you show up, okay, Mr. Rodriguez?
I can't even
Make
hear
sure
you.
you show up for your next court hearing when you get your notice, okay?
Yeah, I can show up. It's not a problem.
Okay, good.
All right.
Make sure you got the right address though. 1235 Southwest 29th Terrace.
Well, guess what? That's gonna be.
'Cause that's what happened.
That's going to be your responsibility to let the
Yes, ma'am.
clerk's office know your correct address. So once,
That's the problem we had last time, Your Honor.
well, it won't be a problem if you give them the right information. So once you get out, you go to the clerk's office and make sure that they have your correct address.
Yes, ma'am. Yes,
Right?
ma'am.
Okay. Daniel Rodriguez.
Morning.
Good morning, Mr. Rodriguez. You are before the court on a misdemeanor KPS for open container matter. The court does find probable cause.
I would like to resolve it today.
All right, Mr. Rodriguez, is it time? All right, Mr. Rodriguez, you'll be sentenced to adjudication and time served.
Okay.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
You understand you have a right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Is anyone forcing you to resolve your case?
No.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, sir?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir.
Thank you.
Victor Hupio.
Your Honor.
Good morning, sir.
Good morning.
You are
Tristan Rosales.
yeah, let's see. You are before the court for loitering or prowling is count 1, and count 2 is resisting officer without violence. These are both misdemeanor charges. I do find probable cause. State, would you have an offer for Mr. Hupio?
Being adjudication, time served.
All right.
And,
He wishes to accept the state's offer, Judge.
All right. How do you say your last name, sir?
Pupio.
Hupio. Okay, I'm correct. All right. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Hupio, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
Ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Is anyone do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, what plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck. Jesse Lebrecht.
Come on up, sir. He's approaching, Judge.
All right, Mr. Lebrecht, you are before the court for possession of cannabis 20 grams or less, and count 2 is trespassing, failure to leave property. The court does find probable cause.
Judge, in speaking Mr. LeBright, he wishes to resolve this matter today.
All right, Steve, do you have an offer?
the offer would be a withhold court cost on 1, adjudication, time served, no return on 2.
He wishes to accept the state's offer, Judge.
All right, the court does find probable cause. Mr. Lebrecht, you wish to resolve your case with the offer that's been presented?
Yes, ma'am.
All right, sir, please raise your right hand. You swear or affirm to tell the truth?
Yes, ma'am.
Okay. Mr. Lebrecht, do you understand everything that's going on here today?
Yes, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
And you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given. On count 1, your sentence is a withhold, adjudication, and court costs. On count 2, it's adjudication and time served. All right? Good luck, sir.
Good luck. Thank you.
Corey Simpson.
Mr. Simpson is approaching, Judge. He's here in Maine.
All right, Mr. Simpson, you are before the court on 2 counts of a traffic capias. One is a driving while license suspended, and two is also driving a suspended license. The court does find probable cause, and Mr. Simpson is scheduled for court tomorrow. What does he wish to do?
Judge, it's me, Mr. Simpson. As you can see, it's a 2017 and 2018 offense. He wishes to resolve these matters today.
All right,
Your Honor, I do not have an offer. I can tell you the $15,000 bond, that was for a failure to appear in non-jury trial. I'd ask that, he's scheduled to see Judge Brown tomorrow on
Okay.
both cases. I'd ask that they be left in place.
all right. All right, yeah, Judge, 15,000. Well, you didn't show for a jury trial. All right, Mr. Simpson, you'll see Judge Brown tomorrow. Is it Judge Brown, you said?
I believe so, yes.
Okay, so, you'll be able to, discuss your case further with your division judge tomorrow. All right, John Zabriskie.
Mr. Zabriskie is here present, Judge. I mean, come on up, sir.
Mr. Zabriskie, good morning.
Good morning.
You are before the court. Count one is a DUI, alcohol or drugs. Count two is DUI with damage to property or person. Count three is leaving the scene of a crash involving damage. And count four, which is not for magistrate, is careless driving. The court does find probable cause. Esteban?
Judge, I'm going to be asking the court to consider releasing Mr. Zabriskie, ROR. My understanding is this is his first contact with the criminal justice system. He's 56 years old and been living here his whole entire life. He's a registered voter here. He works at a retirement home where he's been there for about 10 years, making approximately $13.75 an hour. Right now, he's going through a divorce, so he's living in Pompano Beach where a friend is helping him out during this time, and that's where he's staying. The situation is, unfortunately, when he was arrested, he doesn't have any phone numbers memorized. He can't get in touch with anyone. That's why I'm going to be asking the court if the state can confirm he has no prior record to consider releasing Mr. Zabriskie, ROR. If that doesn't have to be true, then we're going to be asking for standard pretrial release.
Your Honor, he has no record. I have no objection to pretrial. I'd ask no alcohol or intoxicants, random testing. The reason for that and the reason why I'd be objecting to an outright ROR. This case involved a crash where Mr. Zabriskie also left the scene of the crash.
All right, Mr. Zabriskie, I will release you to pretrial supervision with random testing. Sir, the attorney's handing you the information, the directions to the pretrial office. You need to make sure you report within 24 hours of your release. Failure to do so, a warrant will be issued for your arrest. Do you understand, sir?
Yes, ma'am. Yes, Your Honor.
Okay, good luck.
Good luck, sir.
All right. Brandon Giola.
Chairman.
Mr. Giola, you are before the court this morning for count one is burglary on occupied conveyance, and count two is resisting officer without violence, and the court does find probable cause.
Your Honor, I'd be requesting a $2,500 bond. Mr. Giola has a 2016 grand theft. He violated probation last year and was sentenced to 60 days in county jail.
Okay.
Judge, I'm going to be asking for the court to consider releasing Mr. Giola on pretrial release. He's 21 years old, been here 8 years. He is going to school. He goes to Sheridan Tech studying culinary arts, where he goes there Monday through Friday from 7 a.m. to about 1 p.m. Now, he just started a program. I believe he's been there about less than a month. He lives locally here in Fort Lauderdale, and right now he's looking for employment. He's already gone on 2 job interviews. One was with BB&T at the parking lot, and his second job interview was with Checkers So he's hoping to get a call back this week. Hopefully one of them went well. But from right now, from what he advised me, no one can post his monetary bond, and that's why we're asking for the court to consider releasing him on pretrial release.
Just had.
All right, I'll release Mr. Giola to pretrial supervision. Sir, the attorney is handing you the information. You need to make sure that you report to the pretrial office within 24 hours of your release. Failure to do so, a warrant will be issued for your arrest. Do you understand that, sir?
Yes.
All right, good luck. Sean Ganney?
Come on up, Mr. Ganny, correct?
Yes.
All right, Mr. Ganney, you are before the court. Count one is burglary, unoccupied conveyance, unarmed. Count two is petty theft. And count three is a hold for the U.S. Marshal's Office, which is a no bond hold and not for magistrate. The court does find probable cause as to the other counts.
Judge, considering as a no bond hold, I'm asking on count one, third-degree felony, $1,000 bond on Mr. Ganny's behalf.
Considering that he's on supervised release for bank robbery, I'd be asking for a $7,500 bond. He also has priors in Broward for burglary of a dwelling and burglary of a structure.
All right, the court does find probable cause as to count one. I will impose a $7,500 bond. And as stated before, he does have a no bond U.S. Marshal's hold. Devin Martin.
He's approaching, Judge.
Mr. Martin, you have, you're before the court this morning for count one, failure to register motor vehicle. Count two is driving while license suspended. And count three is an out-of-county felony hold, which does have a $25,000 bond. It's it's a violation out of Hendry County. So the court does find probable cause. And your bond on count two is $750.
Good luck, sir.
Jason Bryant.
He's approaching, Judge.
Count five. If we can correct the case number. What is the, oh. All right, Mr. Bryant, you are before the court today for count one is driving while license suspended. Count two is failure to use due care. Count three is failure to provide proof of liability. Those two are not from magistrate. Counts 4 and 5 are felony violation of probation on two separate cases, and those are both no bond holds. You will be before your felony division judge tomorrow at 8:30, and the court does find probable cause, and the standard bonds on the other count will remain. Andre Knutson.
He's approaching, Judge. He's here, President.
All right, Mr. Knutson, you are before the court. Count one is possession of controlled substance without prescription. Count two is possession of drug paraphernalia. And count three is a misdemeanor capias. The court does find probable cause.
Judge, unfortunately, in speaking with Mr. Knutson, he's financially indigent, he's homeless. There's no one that's gonna be able to afford to post any sort of monetary bond. So considering nonviolent offenses, Mr. Knutson is requesting to be released our warrant pretrial release.
Your Honor, I don't believe Mr. Knutson is a good candidate for pretrial. Every time since January of last year that he has been let out of custody, a capias was issued when he failed to show up in court. So far, I'm at 9 separate arrests for failures to appear, and that's just his arrest on failures to appear. That doesn't include his arrest on new law offenses.
Okay. He's been before the court since this year?
I'm sorry?
Has he been before the court this year?
Yes, he actually was before. It was on a weekend, but he was arrested April 5th this year on 2 separate capiases for soliciting.
All right, all right. The court does find probable cause, and Mr. Nelson's standard bonds will be in place. He'll also be before his misdemeanor judge tomorrow at 8:30. Anthony Rodriguez.
Mr. Rodriguez is approaching, Judge.
Mr. Rodriguez, you are before the court. Counts 1 and 2, misdemeanor capias matters, and counts 3 through 6 are felony capias matters. Those are no bond holds and not for magistrate. You will be before your felony judge on May 1st, and then on the misdemeanor cases the following day. Good luck, sir. Corey Neal,
North Broward.
okay?
Brian.
Yes. All right, Mr. Neal, you are before the court on, count 1 is possession of MDMA, and count 2 is possession of drug paraphernalia. And the court does find probable cause.
Attorney.
I'm sorry, sir? What was that?
Yes, Judge, I'm going to be asking the court to consider pretrial release for Mr. Neal. I don't know if the state has an objection to that.
Is based on his criminal history, Your Honor. 2016, unlawful use of false name ID. 2013, possession of cocaine with intent, 3-year state prison. 2013, possession of cocaine, possession of controlled substance, 3-year state prison. 2013, delivery of cocaine, 3-year state prison as a habitual offender. Loitering and prowling, 2013, possession of cocaine, 2012, a year and a day. Delivery of a counterfeit controlled substance, 2010, year and a day. Possession of cocaine, 09, 07. Delivery of counterfeit controlled substance, 06. Delivery of cocaine, 03, 3-year state prison, habitual offender. Possession of cocaine, 02. Delivery of cocaine. It goes on from there, but also, Your Honor, I'd note aliases: Cedric Nesbitt, Calvin Newton. Let's see. Corey Newkirk, Carl Nelson, Corey Nelson.
All right, Mr. Neal's bond will remain at $1,000.
Judge, he has lived here all his life. He lives with his sister. I know he does have a criminal history, but this is 0.01 grams of MDMA found in a syringe that was next to him when he was encountered by the police. And there's no way he's going to be able to make a monetary bond.
All right. Noted, and the bond remains at $1,000. Harold Julian,
He's here, Judge?
all right, Mr. Julian, you are before the court. Count one is petty theft. Count two is possession of fictitious driver's license. And count three is possession of cannabis 20 grams or less, and the court does find probable cause.
Judge, I'm going to be asking the court to consider releasing Mr. Julian on pretrial release. Right now, from what he advised me, his family nor him are in a position to post his monetary bond. He just started a new job at IHOP. He's a server. He lives with his mother in Lauderdale Lakes. Whatever money that they have disposable is going to go towards rent because rent is due tomorrow. Once they finish paying off rent, they're not going to have any sort of money left over to help post his monetary bond. He's been here over 14 years. He's 27 years old. So, Judge, we're asking the court to consider releasing Mr. Julian on these nonviolent offenses on supervision with pretrial release.
State would object. He has 2017 grand theft, unlawful use of false name ID, and a separate case of burglary of a conveyance. He was sentenced to 16 and a half months state prison concurrently. He was released from state prison December 9th of last year. He was arrested and pled out February 6th of this year to a trespass and possession of cannabis. He's also been to state prison out of Broward, burglary of a structure causing damage over $1,000, possession of burglary tools, grand theft, resisting an officer with violence. He was sentenced to 5 years and 5 months state prison, released October 1st, 2016. So it would seem for other than about a year, since 2013, he's been in state prison.
Okay. All right, the standard bonds will remain. Xavier Burton.
He's approaching, Judge.
Mr. Burton, you are before the court. Count one is for grand theft. Counts 2, 3, and 4 are felony violation of probation. Those are no bond holds. The court does find probable cause. You do have court tomorrow in your felony division at 8:30, and the bond on count one is $1,000. Good luck. Alex Coleman.
How you doing, Judge?
I'm doing well. Mr. Coleman, you are before the court for possession of drug paraphernalia. Count two is a municipal ordinance violation. And count three is felony violation of probation, which has a no bond hold. And you two have court tomorrow in your division at 8:30. The court does find probable cause. Your bond on count one is $100.
All right, thank you.
Judge, we've reached, I need to take a break to speak to the rest of the gentlemen after Mr. Coleman.
What?
So I could do the other facilities.
I'm only kidding. Okay.
Yep. Thank you, Judge.
All right. At the North Broward, do we have anyone who's
Yes, ma'am. We have Mr. Thibodeau on page 17.
okay? Good
Morning, Your Honor.
Good morning. Yeah. All right, Mr. Thibodeau, you are before the court for possession of oxycodone. And the court does find probable cause. Does anyone wish to be heard as to bond?
Judge, in speaking with Mr. Thibodeau, he's not going to be able to make a monetary bond. He's been living here in Florida since 1993. He plans to go to Bark if he's released. He's self-employed, he does odds and ends, paints, does lawn work, makes about $200 a week or so. He has some physical issues that make it difficult for him to work or save any money, so he has no money saved. for purposes of posting bond. So I'm going to ask the court to consider pretrial release for Mr. Thibodeau this morning.
One moment, Your Honor. Your Honor, I'd have no objection to pretrial. I would ask for random testing.
That's fine.
Okay, Mr. Thibodeau, I am going to release you to pretrial supervision services. The deputy will give you the directions and the address, all the information that you need to show up within 24 hours of your release.
Yes, ma'am.
If you don't show up, there will be a warrant issued for your arrest. Do you understand that?
Yes, ma'am.
Additionally, you will be randomly tested for drugs or alcohol. Do you understand that?
Yes, ma'am.
All right, sir, good luck.
Yeah.
On page 22, Judge, we have Boris Fayer in North Broward.
Good morning, Your Honor.
Good morning, Mr. Fayer. Do we have Mr. Fayer here recently? It seems like
He was
it's a-
arrested originally February 25th, Judge.
Okay,
I just can't remember if you set the bond originally in this matter or not. I am going to be asking, a bond was originally set at $15,000.
1-5,
Yes, ma'am.
Okay.
Well, on the aggravated stalking, I don't know what number it is on yours.
okay.
I know in the book it's 8. I'm going to be
says
asking
8.
that be reset, plus pretrial release of the GPS monitor. Your Honor, just so the court's aware, he's being held on a violation of probation on a battery, violation of a injunction. He's being court ordered, held no bond on a separate violation of injunction. And he also is being court ordered no bond on a grand theft, fraudulent use of personal identification information. Every single one of those cases involves the same victim as this case, even the grand theft, Zenaida Fayer. I'm also going to be asking, in an abundance of caution, in order of no victim contact in this case.
All right, Mr. Fayer, you are before the court. This is now charge number 8 for aggravated stalking after injunction. So, the court does find probable cause. I will, keep the bond at $15,000 that was previously set. There'll be no victim contact, sir. That means no phone calls, no texting, no social media, no asking a third person to be in touch with the alleged victim. It means what it says, no contact. Do you understand that, sir?
Yes, Your Honor. Can I talk?
Maybe you shouldn't.
No, I wouldn't say anything at this point in time. You need to go in front of your division judge, Boris.
Your Honor, I can appeal to Honorable Court. My wife, Zenaida Fayer, several times lied to Honorable Court. We never
Boris,
divorced.
I'm really advising you
And she
not
keep-
to say anything.
She keep all valuable stuff from all my family.
Sir, do you have ears? Can you
Yes.
hear? Did you hear
Yes, ma'am.
did you hear your attorney tell you not to talk about the case? Okay, so you'll talk to your attorney when your attorney comes to meet with you to develop your defense. Do you understand that?
Yes, Your Honor.
All right, sir, good luck. Is that what it was before?
I don't know if it was addressed as a misdemeanor, frankly, Your Honor.
Well, he's got other things going on, so, yes. Briantis, who else do we have at North Broward? Anyone else? That's it?
Yes, that's it.
Thank you, Deputy.
Welcome.
At Conti, do we have anyone?
No, ma'am.
All right, thank you. Good
Thank you.
morning.
Good morning, ma'am.
Paul Ryan?
No, Your Honor, we have nobody.
All right, thank you.
Your Honor.
All right. Okay. Briantis Mitchell, bond was posted. Is Mr. Mitchell in the room? All right, so Mr. Mitchell's bond has been posted. All right. All right, we can be in a brief recess until everyone is ready.
behalf of Mert Balta for the record.
Okay. All right, Mert Balta.
He's approaching, Judge. Mr. McGill, your private attorney is right there in the bottom middle screen, okay?
Yes, ma'am.
All right, good morning, Mr. Balta.
Good morning.
You are before the court today for 2 counts of touch or strike battery, and count 3 is a criminal mischief. The court does find probable cause. Counsel?
He's lived in the county his entire life. He does have prior arrests. However, as far as I know, all those cases were with no process, no information. I'm not sure if he's working. I do know that the only place where he was working was his residence, but I understand that he in contact order. We were looking for a $3,500 bond on each case.
Okay.
No, that's fine. I guess was speaking with Mr. McGill before, and I guess we should have formalized, that's what we were talking about, so.
Okay.
I'm fine with 3,500 on counts 1 and 2.
All right.
500 on 3, no victim contact.
All right, so, I will accept those, bond amounts. Mr. Balta, there will be no contact with the alleged victims in this case. And so I understand that this may be a familial situation, but you are not allowed to have contacts until further order of the court, okay?
Yes.
So if this is where you were living, I'm sure your attorney will let you know that you will have to find somewhere else to be, okay?
Yes, ma'am. Yes, ma'am. No problem.
All right.
And I also wanted to say I have a job.
You have a job?
Don't talk
Okay.
about it. Don't talk about
Yeah.
anything, okay?
All right,
I'll take care of everything.
just talk to your attorney when in private,
Yes.
okay?
Okay.
All right, good luck, sir. Thank
you very much, sir.
Nice to see you.
What did you say?
Mr. Romero, were you ready?
I'm ready, Judge. I was trying to figure out something. Okay. Why didn't you just say that?
Do we have Morris Thomas?
Come on up. And Judge, we're going to be waiving formal reading of the charge.
Okay. All right, as to the charge presented, the court does find probable cause. I'll hear from the parties as to bond.
Your Honor, I'm actually going to be seeking a no bond hold upon the finding of proof evident or presumption great under Florida statute 794.011, 4E2. In this situation where the defendant is a person 18 years of age or older, and the victim is 12 years of age or older but younger than 18, and the offender coerces the victim to submit by threatening to use force or violence likely to cause serious personal injury on the victim, and the victim reasonably believes that the offender has the present ability to execute the threat, that is punishable by a term of years not exceeding life. In this instance, Your Honor, the allegations from the victim are when the defendant confronted the victim in the bathroom, he threatened that if the victim did not perform the act he was demanding, that he would kill the victim. The victim stated he complied with the demand out of fear, as Mr. Thomas is substantially larger than him and had the physical ability to carry out the threat. Your Honor, the victim's sworn statement would satisfy the elements of the offense. There's, I believe, one moment, Your Honor. There was video surveillance placing Mr. Thomas at the exact scene of where this incident occurred, and there is also DNA evidence implicating Mr. Thomas as committing the offenses alleged by the victim.
We would object to the court making a finding of proof evident presumption great at this point. I have read the affidavit to which the prosecutor refers. Proof evident presumption great is the highest standard of proof that we have. The state has produced no evidence, no testimony, and no DNA report. So we would submit to this court that the state has failed to meet that very high burden, and we would ask you to set bond for Mr. Thomas.
All right, the court does find probable cause, and upon review of this affidavit, the report, it is alleged that the report came very soon after the actual incident, that there was DNA testing done that is mentioned in the report that has been provided to the court, and also that there are statements from the minor victim. Based on that, the court is going to make a further preliminary finding of proof evident presumption great. This is without prejudice for the defendant to further have a bond hearing based upon state v. author. With the finding of proof evident presumption great, the court is going to hold Mr. Thomas no bond until further order of the court. Court will also note no victim contact in any form. All right. Okay, sir. Alberto Gomez.
Mr. Gomez, come on up, please.
Mr. Gomez, you are before the court. Count 1 is grand theft. Count 2 is false owner info for pawned items. Count 3 is dealing in stolen property. And count 4 is felony violation of probation. You do have court tomorrow in your division at 8:30, and you also do have a bond on the violation of probation matter, $5,000. Parties wish to be heard as to any of the bonds?
Mr. Gomez is advising the judge, unfortunately, he can't afford anything right now. What he does is he gets jobs occasionally washing cars, washing vehicles. He also lives locally in Hollywood, where he helps the property owner maintain the property, and in turn, he's allowed to live there. But right now, from what he advised me, no one can help host. He can't afford anything, so I'm asking the court if the court would consider releasing him on pretrial release, Judge.
He's fortunate that he even has a bond on the VOP, considering this incident happened 9 days after he was placed on 2 years probation on 2 separate grand thefts.
All right, the standard bonds will remain in place. Good luck, sir. Rohan Moistin.
Mr. Morrison is approaching, Judge. He declined the services of public defender. Morning, Judge.
Good morning, Mr. Moiston. You are before court. Count 1 is driving while license suspended. Count 2, failure to register vehicle. Count 3, attaching registration plate not assigned. 4, attaching registration plate not assigned. 5, expired driver's license over 6 months. 6, violation of driver's license restriction. 7, expired motor vehicle registration over 6 months. And 8, failure to provide proof of liability security. The court does find probable cause. Mr. Moisten, do you have private attorney, or you plan on hiring counsel?
Yes, I'm hiring an attorney, ma'am.
All right, sir. So, there's one more. Count 9 is failure to wear a safety belt, but that's a traffic infraction, not for magistrate. The court does find probable cause. Your bond is $750. You have a total bond of $750, sir. Good luck.
Thank you.
Jamie Militana.
Mr. Montana is approaching, Judge. He's here at me. Come on up, sir.
Good morning, ma'am. Good morning, ma'am.
Good morning, sir.
Your Honor, if I could be heard before the
Sure.
court makes a determination. Your Honor, I read over the statutes, and to be candid, I don't believe there is probable cause for count 1. I believe there is probable cause for count 2. Florida's, in Chapter 790, under the definition for destructive device, this statute specifically states that a shotgun is not to be considered a destructive device.
Okay.
However, count two, while on the maybe on your findings on the booking, it just mentions explosive weapon or mass destruction. The statute also includes firearms, threats by use of firearms.
Okay. All right.
I would agree with that.
All right, so Mr. Militano, just so you understand, there were two charges that were presented this morning. One was threat to throw or place or discharge a destructive device, and two is a false report of bomb, explosive, or weapon of mass destruction. As you've heard from the prosecutor and the court, and the defense attorney agrees that there are no elements as to charge number one. So the court will not find probable cause as to one, but does find probable cause as to two, okay? All right, does anyone wish to be heard as to bond?
Your Honor, I'm going to be requesting a $15,000 bond on count two. No return to the business involved in this matter, Puppies and Rescues at 8961 Taft Street in Pembroke Pines. I'd also ask for an additional release condition that Mr. Militano not be in possession of any weapons or firearms until further order of the court. He does not have any history of note that I can see, Your Honor. This recommendation is based solely on the allegations and concern for safety of the community based on the allegations.
Judge, under the circumstances, that's reasonable. Nothing to add from the defense, Judge.
All right. So the court will impose a $15,000 bond, no return to this location, and until further order of the court, no weapons or firearms, sir. Do you understand?
Yes, ma'am.
All right, sir, good luck. David Godin? Okay,
He bonded, Judge?
thank you.
Favors?
Xavier Favors?
He's approaching, Judge, here at
This
me.
bond has been posted? Okay. All right, Mr. Favors, your charge is grand theft, and I do find probable cause. I've been advised your bond has been posted. Good luck, sir.
Good luck, sir.
William McDonald?
Mr. McDonald, come on up.
All right, Mr. McDonald's bond has also been posted. All right, good luck, sir. Quinzel Bell?
He's approaching, Judge, here at me.
All right, Mr. Bell, you are before the court. Count one is aggravated assault with a deadly weapon without intent to kill. And count two is possession of a weapon or ammo by a convicted felon. And the court does find probable cause.
Your Honor, I'm going to be requesting that the court keeps the bonds that Judge Bober set in place with additional release conditions, pretrial release with a GPS monitor, no victim contact, in order that Mr. Bell not be in possession of any firearms, weapons, or ammunition until further order of the court. Your Honor, I have concerns based on the allegations that first, Mr. Bell armed himself, withdrew a firearm in the presence of the victim while there were children present, and then followed that up by opening fire and discharging the firearm at the alleged victim. Additionally, Mr. Bell's criminal history at Dade County, attempted second-degree murder and felon possession of a firearm or ammunition or weapon. 2003, he was sentenced to 12 years in state prison, was released December 7, 2014. 2001, he was convicted of a felony battery, sentenced to 5 years in Florida State Prison. Those are his most significant priors that he went to state prison on.
Okay.
Judge, we'll get into it. Judge, in speaking to Mr. Bell, currently the bond is set at $40,000. His family nor him is not going to be able to quite afford that. I'm gonna ask the court to consider reducing the bond on count one from 25,000 to 10,000, and on count two from 15,000 to 5,000. So the defense is requesting a total of $15,000 on Mr. Bell's behalf. Now, he has been here his whole life, Judge. He is working. He works for a construction company. He's been there with the same construction company since January of this year, and he's currently making approximately $11 an hour. He lives with his mother. They reside in Miami, and their monthly rent is approximately $700 per month. Now, he's going to be reaching out to his mom, his sister, his family to help post a monetary bond. His mom does work. She drives school buses for a living. So that's who she's going to be relying on to post this monetary bond. So if the court could impose somewhere in the neighborhood of $15,000, he believes his family can come up with that.
All right, the court does have great concern. The allegations for the community, the allegations are that Mr. Bell did discharge a firearm. And yes, the allegations does show that there were also children in the area at the time. So I am going to leave the bonds that are in place, 25,000 and 15,000. I'm also, if Mr. Bell posts his bond, he will be on a level 2 GPS. And also, no weapons or firearms until further order of the court.
And Your Honor,
No victim contact.
thank you.
Okay, Andrew Benito.
He's here, Judge.
All right, Mr. Benito, you are before the court. Count one is grand theft auto. Count two is false ID given to a law enforcement officer. Count three is resisting officer without violence. Count four is introducing contraband into the detention facility. And count five is possession of PVP.
Your Honor, he's currently out on pretrial for case number 190051990CF10A for burglary structure unoccupied Pleasant's pretrial revoked. He was placed on pretrial this year.
Okay?
Judge, the only thing I can let the court know is right now Mr. Benito is financially indigent. He's homeless. He works when he can, but at a beach with helping out with chairs, but that's not often. He's trying to look for more regular employment, but he's been unsuccessful, and there's nothing he can afford, Judge.
All right, so Mr. Benito was placed on pretrial supervision for the charge of burglary, structure unoccupied. Was given the benefit of not having to post a bond on that arrest. And then now he's before the court on some theft charges in addition to everything else that I said. So at this time, the court is going to grant pretrials, request to revoke pretrial supervision. And I'm going to issue a no bond hold on that charge. As to the new arrest, I will leave the standard bonds in place. Jonathan Ductent. All right, sir, you are before the court. Count one is possession of cannabis 20 grams or less. Count two is driving while license suspended, third or subsequent offense. Count three is unlawful speed. Count four is improper passing on the right. Counts 5, 6, 7, 8 and 9 are misdemeanor capious matters. 7, 8, and 9 are no bond holds, and the court does find probable cause, and the bonds are in place.
Okay, Your Honor, may I please address the court?
Okay.
Okay, Your Honor, I'm a 27-year-old black male. My name is Jonathan Ducktant. I reside in Miami, Florida. I give life 1,000%. I currently have 2 kids, 2 beautiful daughters, and I have a mother which love me very, 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 very much. She's Haitian, and she currently can't walk right now. With me being here right now, I have missed work today, and my car's in a pound. I don't know how my daughters made it to school today or how they're gonna get picked up today. The capias that the state are talking about, I'm very, very 1,000% sure. I'm adamant that I went to the clerks of court and I wrote to the clerks of court. The same issue occurred with me last time, and I'm pretty sure you remember me. You are me, and I appreciate that, miss. The same issue occurred. I had wrote to the clerks of court, and the state found a piece of paper of me writing to the clerks of court, telling them the reason why I couldn't make it to court. So if I can ask the state to look for the on a piece of paper that I wrote to the judge, telling the judge the exact reason why I couldn't make it to court, because I'm pretty sure it's in there, and I'm pretty sure Miss Your Honor, God puts people in places and positions to do things for people. You get where I'm coming from? And I'm a Christian man, and God is all I have and all I ever had. You get where I'm coming from? I give 1,000%. I got 2 beautiful daughters and a mother that can't walk. I'm the only one that's out here. And my car's in the pound. I missed work today. If I can ask the courts, the police are I give 1,000%. I'm not some hardened criminal. I have no DUIs, no guns, no burglaries, no. I'm not trying to downplay any of these guys that have that, but I give 1,000%, and I'm a stand-up citizen. I'm in school as well over there at North Perry International Airport. If I can ask the courts to please RR me so I can get my car, pick up my daughters from school today, and I'm definitely showing up to court, and I'm pretty sure the state can see that I just paid over $2,000 in Miami-Dade tickets, as well as $600 in Broward County tickets. So you guys can see I'm a guy that's actually putting effort and towards bettering myself. Appreciate that, Miss, for hearing me speak.
Frankly, it's time for Mr. Duckton to see his judges in Broward. On the 2018 case, he's had 2 capiases withdrawn based on his request. And each time, and then again, he doesn't show up. He keeps not showing up. He's got a warrant out of Dade County for failure to appear in a DWS right now. And the only reason he's before the court is because he continues to drive illegally. He refuses to stop driving illegally. Oh, he's got a warrant out of Georgia, too, for a failure to appear.
All right, Mr. Duckton, I can appreciate what you've said this morning. However, you are before the court for 9 counts, and these are not all capious charges. Some of them are new arrests. So your bonds are going to be in place, and you have court tomorrow and the day after. So your attorneys will have time to investigate whatever it is that you said in regards to the capious matters. Good luck, sir. All right, can we have Antoine Holston?
Mr. Holston's here, President Judge.
All right, Mr. Holston, you're before the court for burglary, unoccupied structure, unarmed. This is a change of charge?
It was filed as an attempt, Your Honor. I pulled the probable cause affidavit, and it's clear. Your Honor said on this count,
Yeah.
on all the burglary counts, but in this one included, $10,000 pretrial release of the GPS monitor level 1. Your Honor, if you'd like, I could print out the PC for you. It's clear on its face. It says.
Did we make a finding for attempt also before?
It wasn't written in, but.
It wasn't written in.
I'm looking at the PC. It's the clear language says that it was an attempt.
All right.
Judge, he's been in for almost 40 days or more, and on the burglary offenses, he has $10,000. I mean, he's still here, and that's evidence he just cannot afford to post that monetary bond. Considering now, I mean, it's officially what's here before you is an attempted burglary. It's third-degree felony. I'm going to be requesting a $1,000 bond on this case.
Your Honor, the reason I believe why the court set the bonds, where you said, because you said 10,000 on all the burglaries, there were One moment, let me see how many burglaries there are. There are now a total of 5 burglaries that he was arrested on that have been filed. But I believe the court also considered his criminal history. 2016 grand theft auto, just under 27 months state prison. 2016 burglary of a structure, same sentence. 2014 escape, 21 months in Florida state prison.
All right. I'm gonna leave the bond in place at $10,000. This is charge number 6. All right.
And Your Honor's keeping all the other release conditions
All the
previously
other
set.
conditions will apply.
Thank you.
And then we have Olguin Gonzalez.
North Broward, I believe, Judge.
Thank you. Well, they had said they had no one else. Olguin Gonzalez?
Good morning, Your Honor. He's actually in downtown court.
Oh, okay. All right, thank you, Deputy.
You're
All right,
welcome.
we'll have to reset Mr. Gonzalez when he's back, okay? All right, everyone, I think we've reached the end of our docket. I'll see everyone this afternoon.
Will you reach that green for the PM?